Welcome everyone to yet another session on WTO law. Today we'll talk about non-tariff barriers, first and foremost quantitative restrictions, but also other non-tariff barriers, among them in particular lack of transparency by state, overly complex customs formalities and procedures at the border, government procurement laws and their impact on free trade, and also two specific product categories where in particular richer states were and are still keen on protecting their domestic producers, textiles and clothing, and agriculture. Without further ado, let's get started. First, what is a quantitative restriction, or as it is commonly abbreviated, a QR? Prohibition, so an outright ban on the importation of specific products to its markets, or quotas, a maximum quantity, a maximum number, a maximum other unit of measure of products that may enter a specific market. In this regard, what is also important is so-called import or export licensing, so the licensing scheme to allow a certain maximum number of products to enter a given market, and there might also be other forms of restrictions in this connection. If a QR is made effective through a state trading operation, if it constitutes a mixed regulation, a minimum price requirement, triggering a quantitative restriction, or a VER, a voluntary export restraint that is, upon closer inspection, often not as voluntary as it may seem. Good. Before we start with the legal aspects, we'll discuss why the GATT prefers tariffs over QRs. There's a number of reasons for that. The first among them is transparency. Why? Because, as you may know as an individual consumer, if you buy something, you have to pay the tariff immediately. So you can see that a certain percentage, for example, has been added to your product, and you do just think that, why do I have to pay 10 or 15% more just because my government wants to protect shoe manufacturers, or who else? I'm mentioning shoe manufacturers because that's what happened to me when a couple of years ago I bought a shoe via eBay, a particularly rare sneaker, and then all of a sudden I had to pay a bit more than expected. Or another reason why the GATT prefers tariffs over quantitative restriction lies in the fact that tariffs are, from historical experience, simply easier to negotiate. Negotiations on tariff are also particularly difficult, as all negotiations in the GATT and the WTO, but it is still easier to reduce tariffs than eliminate quantitative restrictions altogether. Then what you also have in this connection is something called the quota rent. What is the quota rent? QRs, they increase the price of the imported products. Why? Because if you have a maximum number of products that may enter your market, this number of products, these products are artificially made more expensive. Why? Because there is shortage of these products. Because if there is a demand for 10,000 cars and only 1,000 cars are allowed to enter a given market, these cars that have entered the market will be more expensive because they are more rare. So consumer demand is not fulfilled here, is not satisfied here. And this artificially higher price, that however is called the quota rent, and this is what the importers benefit from. However, you want to prevent importers from gaining or benefiting from such a quota rent, another reason why the GATT prefers tariffs over quantitative restrictions. Another fact lies in the simple historical observation that quantitative restrictions are also susceptible to corruption. Why? Because to administer such a quantitative restriction, you need a licensing system. And this, however, means that government officials, authorities, civil servants, they decide whether to grant or not to grant an important license, at least, however, if it's not an automatic licensing scheme. And there, however, it could well be the case that they don't decide on whether specific requirements are being fulfilled, but they have been given some money, for example, to say, okay, couldn't you just give us the license to import to your market? So corruption, yet another reason why we don't like, and why the GATT doesn't like, and why the WTO doesn't like quantitative restrictions. And last but not least, a simple economic rationale. Why? If there is, for example, a ban or a maximum number of products, and a very low one that is, that means that competition will not be able to, you could say, to work its magic. Why? Because even if the most efficient consumer simply can't export more, the most efficient producer simply can't export more than a given quantity or can't export altogether, it doesn't matter how good the product is, it simply won't be able to compete at the same level or not be able to compete at all. This is the economic reason why the GATT prefers tariffs over quantitative restrictions, because there at least the products will be able to enter the market. Maybe they will be made artificially more expensive, but nevertheless, at least they can compete, even if they are, however, a bit more expensive because they have been imported from another country. So, where do we start now that we want to discuss the legal aspects a bit longer? Article 11 of the GATT. This is the key provision in this regard. So you've now encountered a number of provisions already. Article 1 on most favored nation, Article 2 on tariffs and tariff bindings, Article 3 on national treatment. The next important rule you need to remember and that you should also look at in the original version, because as I've discussed over and over again when it comes to the GATT, sometimes it is not as clear as it may seem when reading textbooks or listening to lectures. So, Article 11 of the GATT, and as the title already holds, includes a general elimination of quantitative restrictions by simply stating that no prohibitions or restrictions other than duties, taxes, or other charges, whether made effective through quotas, import or export licenses, or other measures, shall be instituted or maintained by any GATT member, i.e. contracting party, on the importation of any product of the territory of any other contracting party, i.e. GATT or WTO member, or on the exportation or sale or export of any product destined for the territory of any other contracting party. So, restrictions both when it comes to imports and when it comes to exports. What you can see here is that GATT members are restricted in their sovereign right to take measures at the border when it comes to influencing the given market, influencing trade flows. They have committed themselves to say free market reigns. We will only on a very limited level impose any bans or quantitative restrictions. And there is a broad definition of these quantitative restrictions. So while I've been talking about bans and maximum numbers over and over again, there is also a reference to so-called other measures. Among them, for example, export quotas, minimum import price requirement, discretionary and non-automatic license systems applied by states, or restrictions on ports of entry, so where and how a product may enter a given market. So what you can see here is that also all other measures a state may take to prevent the importation of certain products to its markets or also the exportation, they are also caught by the broad prohibition of GATT Article 11. Purely domestic measures, however, are not covered by Article 11 of the GATT. What do we mean by that? This is where the national treatment obligation becomes relevant. However, once a product has already entered the market, Article 11 becomes inoperative. That, however, requires us to look a bit further into detail, to go a bit further into detail concerning the relationship between GATT Article 3 on national treatment and GATT Article 11. Because GATT Article 3 affects imported products, whereas GATT Article 11 is affecting or regulating measures that affect the actual importation of products. So while they're standing at the border waiting to enter a market, whereas Article 3 says, okay, now you've already entered our market, okay, now I'm going to take care of you. You can imagine it like this. You go to a cinema, the one person checking whether when you enter the big room with a giant screen, the one who is checking your entrance ticket, this is Article 11. The one person that is inside of the cinema, obliged not to discriminate you, this is Article 3, if you allow me to draw this picture to make this a bit more lively. But this difference is not only of theoretical importance, but also is decisive in actual implementation of rules. Why? Because Article 3 prevents discriminatory internal measures, so non-discrimination principle between domestic and foreign products, whereas Article 11 concerns entirely different aspects simply by saying that, okay, how many products may enter your market. The big question, however, is what if a purely internal market measure, so let's say the tax is already imposed or enforced at the border. If you collect the tax already once the product is trying to enter your market, this was also in the minds of the drafters of the GATT, and there was a note at Article 3, or the negotiators of the GATT, more precisely, and also in the decades that followed, they stated, made it clear that an internal measure is an internal measure, even if it is, and I quote, enforced or collected in the case of an imported product at the time or point of importation, end quote. So that we can see here the area or the point or the geographical location where a measure is taken is not relevant here. What is relevant here is what type of measure is being implemented here. When it comes to export controls, so things that are done when a product leaves a certain territory, in Article 11, there is no GATT obligation against the use of export taxes or export fees, and there are rather broad exceptions for restrictions on exports in the GATT. That also needs to be remembered. So whereas there is a prohibition of quantitative restrictions on export or concerning the exportation of products, nevertheless, export taxes or export fees are not regulated directly by the GATT. What types of quantitative restrictions then exist? As we've discussed already, there are outright prohibitions, so a total ban. This could be done for a number of reasons, and that's why they are not prohibited in all cases. So, for example, a country may rely on its public morals or its public security to prevent a certain product from entering its market. So, Saudi Arabia, for example, prohibits the importation of foreign editions of the Quran because they say that only domestic editions of the Quran are the real ones, and we don't want any foreign ones because they might be misleading or they go against our specific interpretation of Islam. Or public security, so European Union, Australia, they ban a lot of weapons from entering the market, the European consumer market, simply because they are held not to constitute or not to be designed for individual consumers. And then there are also other types of quantitative restrictions, quotas. This is a numerical restriction on imports or exports. They have to be, however, differentiated from so-called tariff quotas. What is a tariff quota? This is somewhat misleading because the word quota is inside here or is mentioned here, but this is a quota or a tariff that says that a number of imported goods benefit from a specific customs rate. And then once this number has been reached, you'd say, okay, the first 500 tons, no tariffs. The second set, the second 500 tons, then a 10% tariff. And then the third tier, 500 more tons, then you'd say, okay, 15% tariffs or 20% tariffs. So you could say, okay, depending on how many products enter our market, there will be different tariffs applied. That by itself, however, even though the name it says tariff quota, is not a quota in the sense of GATT Article 11. Keep in mind there is a difference here. And then there are also other measures, i.e., as we said, any requirement or regulation that is designed to inhibit imports or exports, so export quotas, data collection, monitoring requirements, a minimum price system, required security deposits, restrictions on ports of entry. They can all be compatible, but it can also be incompatible with GATT Article 11. What I can say at this point is you have to assess it on a case-by-case basis. Good. What are the main issues in connection with GATT Article 11? First, it applies to all measures a state takes in connection with the importation or exportation of products. And as I said, the residual category of other measures. It doesn't also not only rely or refer to laws or regulations. So again, a very broad concept. Laws and regulations are obviously the main tool in the toolbox of states when applying trade measures, but not the only ones. So indirectly, as you've heard a few minutes ago already, voluntary export restraints, they say they're voluntary, but they are also covered by GATT Article 11. The type of enforcement is also not decisive here. So it might be through customs regulations, or they might be implemented by state trading companies or import monopolies, so governments. not themselves directly do that, but they say, okay, we'll transfer the task of applying a quantitative restriction to a private company or a company that might be constituted as a private one but is entirely held and controlled by a state. That, however, is not decisive for the operation of Article 11 to become operative. That quantitative restrictions that do not have an actual trade impact are also prohibited, and what is also mentioned here, or what also needs to be mentioned here, are de facto quantitative restrictions. So even if a measure limits actual trade and has an effect but does not constitute a prohibition or impose a numerical limit, they may also be prohibited. What is necessary here is to determine the design, architecture, and structure of a specific measure, and in some cases even non-obligatory or voluntary mechanisms might also constitute a quantitative restriction. And therefore, even legally non-enforceable measures are addressed if, first, there are reasonable grounds to believe that they will be effective and if the measure depends on governmental action. So one example from European Court of Justice case law that goes very far is a governmental campaign to call on people, call on consumers to buy domestic products. So the so-called Buy Irish case from the early 1980s, where the European Court of Justice said that a campaign that was more or less indirectly organized by the Irish Ministry of Trade, calling on people to buy domestic products, to buy Irish products, even constituted a prohibited quantitative restriction, however, inside of the European Union. If the WTO would go this far and also say that state campaigns to convince people that they should buy domestic products also constitute a violation of GATT Article 11, well, that's up to debate. And as you can see, for example, during the coronavirus crisis, there is also a higher likelihood that governments will then appeal to nationalist sentiments or to their domestic consumers and say it's better if you buy local. That is emotionally understandable, but at the same time, also there is an obvious tension to GATT Article 11 or also the European, if we talk about the European Union, the European Union's prohibition of quantitative restrictions and other measures that may constitute a quantitative restriction or have a negative impact on cross-border intra-EU trade. Good. The scope of Article 11 of the GATT, and where does all of that come from, what I just mentioned, is, for example, or has been further outlined already by the GATT in the case concerning trade in semiconductors. Remember, during the 1980s, Japan was to many what China is today. So a rising star, a rising economic star, rising economic powers, and particularly in the US, there was a lot of fear that Japanese companies would take over the US market and drive out US electronic companies out of the market. And it was held here in the panel report by the GATT. The wording of Article 11, paragraph 1, and now I quote, was comprehensive. It applied to all measures instituted or maintained by a contracting party prohibiting or restricting the importation, exporting, or sale for export of products other than measures that take the form of duties, taxes, or other regulations. And then it went on to say that the import regulation allowing the import of a product in principle but not below a minimum price level constitute a restriction on importation within the meaning of Article 11, paragraph 1. So what you can see here, even a minimum price requirement by itself may also constitute a quantitative restriction covered by GATT Article 11, paragraph 1 of the GATT and therefore be unlawful. However, what I also want to emphasize here is that there is almost no rule without exceptions, except for the rule that there are no rules without exceptions. So what you can see are 3 different examples that are mentioned in GATT Article 11, paragraph 2. So whenever reading an article and you read the first paragraph, you can be certain that usually the first one will be the most important one, the one laying out the general field of application and the general notion what is behind this rule. However, there is usually a paragraph 2, or in another sense, another paragraph that will say, okay, but there might be some situations where you can deviate from a certain obligation. And in Article 11, that's paragraph 2, that says first, if there is a critical shortage, you may on a temporary basis apply a quantitative restriction. If a restriction is necessary to apply certain commodity standards, that may also be imposed. and in cases of balance of payments problems. So if a country has a problem with another country, say, okay, we're out of balance here, you may also temporarily rely on quantitative restrictions, and that is also further regulated than in GATT Article 12 and GATT Article 17. And this brings us to current events and the coronavirus crisis. There have been numerous reports of countries imposing export restrictions. So one example is the US, where Mr. Trump, on the basis of the Defense Production Act that gives him the legal power to ban the export of crucial medical supplies that are needed for the US market. So what you see here, there is US legislation says on the one hand, the US can call on or direct companies to produce certain products if there is a shortage or a fear of shortage, and it can also prevent the further exportation of such products if they are needed in the US market. So this is also what is behind some headlines where you could see that, for example, a number of weeks ago, I remember that there was a headline that in Thailand there was a stop, the exportation of certain products was being stopped there. The basis of this was the US Defense Production Act. So Trump acts to head off key medical exports, calls out 3M again. And however, the US was not the only country doing that. A large number of countries did that because they said, okay, now America first, but also Germany first. Think of what Germany did in the early days of the coronavirus crisis, also banned the exportation of medical gear, of face masks, of other pharmaceutical and medical products over fears that they might be a shortage in the German market. So, however, the relevant provision here from the perspective of world trade law is GATT Article 11. So, the first one permits, as you could see, members to prohibit or restrict exports of, most importantly, foodstuffs, but also other essential products, however, only on a temporary basis, because otherwise there would be no sense having Article 11 at all. And also you need to prevent or relieve critical shortages. So exactly what happened during the coronavirus crisis. Then the second main exception to GATT Article 11 is if you take measures that are necessary for, and I quote, the application of standards or regulations for the classification, grading, or marketing of commodities in international trade. So, and the third one then refers to agricultural or fisheries products that are necessary for the enforcement of governmental measures that, first, that restrict the marketing or production of the like domestic product, that remove a temporary surplus of a like domestic product if you have overproduction in the agricultural sector, for example, as it happened in the European Union, as it also happened in the European Union right now. Why? Because there was less, it was not demand, but it was more important and more difficult to export, for example, dairy products, milk products from the European Union, or if it is necessary as a third exception, to restrict the production of any animal product that is directly dependent on the imported commodity if the domestic production of that commodity, however, that's the precondition, is relatively negligible. Good. However, if you impose such quantitative restrictions on an exceptional basis, certain rules are nevertheless necessary to be applied with. So, non-discrimination, there is a specific rule, not only MFN, but also a more specific one referring to the administration of quantitative restrictions to be found in GATT Article 13, paragraph 1, that if there is a quantitative restriction on products from one member, the like products from all other countries are similarly prohibited or restrictive, as GATT Article 13, paragraph 1 of the GATT says. Then there are rules concerning the distribution of trade. So if you impose a quantitative restriction, then you have to allocate the exports that are nevertheless still allowed on, let's say, on a basis that would be percentage-wise also be expected if there was no quantitative restriction at all. So if you said, we imagine that 80% of our products, if there was no quantitative restriction at all, would go to the US, then you would simply say, okay, now we don't allow all products to leave our country, but those that are allowed to leave our countries, then, however, should remain at 80%. Usually, however, ideally speaking, you would have an agreement here. Otherwise, you would simply look back in the past, what was the allocation, and then keep the percentage. However, the total number would differ here. And also there are rules on import licensing procedures. First, they have to be applied neutrally and administered neutrally. The question whether a license will be granted depends. There are two different ones. One is non-automatic licensing. The one says that automatic licensing says that a license is granted always, and if it's non-automatic, it says, okay, is it being fulfilled? Is the quota already full? What you have here is a first come, first served principle, but however, in practice, these rules are, as you can imagine, more complex, but in general, it's simply say, okay, we have a quota, who are the first ones to get a license? Other non-tariff barriers that need to be mentioned at this point concern all the obligations in respect to transparency. So as you can imagine, if you're a trade partner and you are uncertain what will happen when it comes to trade laws, what will happen at the border, what will happen inside of a given export market, you might think that, okay, we don't really want to export there because there is no rule of law standards. We don't know the laws. We don't know whether the laws have changed. We don't know how foreign exports will be treated. So that's why there is a notification requirement and a publication requirement. Notification means that the WTO Secretariat has to be modified of new rules or modifications of existing rules concerning international trade. So in this case, someone needs to have at least to collect all of these rules, and they also have to be published. So all laws, regulations, judicial decisions by courts, administrative rulings, everything that relates to trade matters, to trade practices has to be published, so that as an outsider you can say, okay, let's look at the legal situation in a country, let's look at what we have to expect there. This, obviously enough, is done also or necessary to ensure an even playing field. Plus, there is an obligation to establish points of inquiry. So if you have a question, what do you do then? Or what should you do then? You can go to a certain point, you call a number, you write an email, you fill out a formula, say, okay, we want to know a bit more about the trade regulations and applications of trade rules in a specific country. This is the transparency obligation these are the obligations in GATT Article 10. You could say this is somewhat the Transparency International or Rule of Law article of the GATT. It says that, as you see here, laws, regulations, judicial decisions, and administrative rulings of general application shall be published promptly in such a manner as to enable governments and traders to become acquainted with them. Long story short, transparency, one of the key aspects or key elements of international business or trade activities in general. And the other sub-paragraph of GATT Article 10, namely 3, also refers to the administration. So yet another rule of law provision in the GATT that says that all GATT members shall administer in a uniform, impartial, and reasonable manner all its laws, regulations, decisions, and rulings, and therefore they shall maintain or institute as soon as practicable judicial, arbitral, or administrative tribunals or procedures for the purpose, inter alia, that means among others, of the prompt review and correction of administrative action relating to customs matters. So again, what you want here are high rule of law standards so that no one will be treated in an unfair manner. Why? Because uncertainty or unpredictability, if you don't know what's going to happen, that also constitutes a trade barrier, because then, as you can imagine, an exporter will be very cautious to export to a country where he or she doesn't know what could happen to its products once they have already entered the market, or if they even try to enter a market. So WTO in general says there needs to exist a uniform, impartial, and reasonable administration of national trade rules, plus all of the procedures for the objective and impartial review of the administration of national customs rule have to be applied. Think of Argentine tenors. This is one case where Argentine tenors, we had a iudex in sua causa problem. What does that mean? If those who are affected by foreign competition get to decide whether to admit and to what extent to admit foreign competitive products, as you can imagine, they will have an obvious bias, they will have their own interests in mind, and that would also go, among others, against the rule of law provision in the GATT Article 10. And in general, there is a large number of WTO decisions, of GATT decisions dealing with unfair and arbitrary administrations of trade measures. Good. What about these formalities and procedures? They themselves, leaving aside GATT Article X, there are only in the GATT few rules on how customs formalities and procedures shall look like and how they shall be administered. GATT Article 8, paragraph 2 of the says that members are obliged to review the operation, so the actual implementation or application of their laws and regulations, with having in their mind the need for minimizing the incidence and complexity of customs formalities. Because as you can all imagine, if there is bureaucracy at work with all of these different points you have to fill out and that takes ages, they should say, okay, no, this, the very essence is, on the one hand, as a state, it's perfectly normal that you want to apply high health standards, for example, or that you also want to say, okay, certain technical standards need to be upheld. On the other hand, however, if that is overly complex, if that is a long form of several hundred pages, exporters will think not only twice, but 3-4 times whether they want to do all of that, whether it's worth the effort. And therefore, documentation requirements and also all the forms and other documents that need to be filled out, they shall be as simple as possible, while also, however, take into account the need to, and the obviously understandable need to uphold certain technical, health, or other standards. So what you need here is a proportionality assessment. On the one hand, the breaches, if they are severe, and at the same time the procedural requirements, if penalties for breaches have to be applied, if a foreign exporter was unable or filled out something wrong, then however you need here a certain proportionality at work, and don't punish them with overly high fines, because then at the same time every consumer will on one hand think twice or 3 times whether producer, will think twice or 3 times whether he or she wants to export in the first place. First, if it's overly complex to fill out documents, and then second, if there are also high fines, high punishments if a mistake was being made, because not all of these mistakes are because you want to circumvent an obligation. It might also be simply the case that it was so complex that it was very difficult and you failed at filling out all of the points. Good. The next other measure possibly constituting a quantitative restriction or a trade barrier, non-tariff barrier, is government procurement. Here, the national treatment obligation of GATT Article 3, paragraph 4 is not applicable. So when a government itself decides to hand out a contract to producers, say, okay, we need to buy more clothes for our military, we need to buy new weapons for our police, here national treatment and the general obligation to not to discriminate between domestic and foreign producers in GATT Article 3, paragraph 4 is not applicable. So a government may itself decide who it wants to give the big fat contract to. There is an agreement on government procurement, however. The big difference here, however, to other treaties in WTO law is that this is a so-called plurilateral agreement. What does that mean? That not all WTO members are members of this agreement, because not all WTO members have to sign this agreement. In general, there is the approach by the WTO is that if you join the WTO, you have to join all of the WTO treaties we mentioned at the very beginning. So GATT, GATS, TRIPS, and so on and so forth. But there are some exceptions, and one of them is the Agreement on Government Procurement. And that's why only some 47 members have become members to this one. Why? Because as you can imagine, most WTO members are keen on protecting their sovereign right to decide to whom or to whom they do not want to offer or give the big fat contracts whenever a government makes a purchasing order, an infrastructure project, and so on and so forth. What is the main aim of this treaty? It's to say, okay, we open also the market, or at least we want here the possibility for all members to this agreement to also bid for the big fat contracts. So to mutually open government procurement markets among the members of the government procurement agreement. It is applicable once a certain threshold has been met. So for the very small ones, if a regional office wants to buy new printer, one new printer obviously does not become operative. It's meant and designed for the big contracts. And the key principle is here not to discriminate between the respective institutions, the respective manufacturers and producers that might be relevant when it comes to handing out such a contract. Plus, what is also necessary here is transparency, because if you want to know that if it could happen that a domestic company gets the contract, but at least you want to know why did it get the contract. That's why there's also a general transparency obligation here. What is also necessary to mention here is, as I indicated earlier, so-called VERs, voluntary export restraints. What is that? This is whenever an exporting country by itself decides that it wants only to export a certain maximum number, as it is usually free, or it could be free to do because it's voluntarily doing that. But at the same time, however, what you see here is that often enough this is not as voluntary as it may seem. There is a huge gray area, and then the question is, okay, can you do that? Usually you can't. And the main cases here is, again, Japan trade in semiconductors. There are two essential criteria here to say whether a voluntary export restraint constitutes a violation of Article 11. The first one is whether reasonable grounds to believe that sufficient incentives or disincentives existed for non-mandatory measures to take effect. So you wouldn't say this is binding, but maybe you exercised economic pressure. There was other backdoor negotiations taking place. And secondly, the operation of the measure to restrict export of the semiconductors, in this case, was at prices below company-specific cost, and this was, however, essentially dependent on government action or intervention. And if these two criteria, so it's a cumulative list, a short list, but a list nevertheless, the measures would be operating in a manner equivalent to mandatory requirements. So although the name says voluntary export restraints, behind it, if you look at it more closely, you'll realize that it is not as voluntary as it may seem, and therefore, in the name of the GATT panel in the Japan trade in semiconductors case, was that there was no doubt that they fell within the range of measures covered by Article 11, paragraph 1. So, and now let's look a bit at other non-tariff barriers, the remaining ones: pre-shipment inspections, marks of origin, measures relating to transit shipments, operations of state trading enterprises, trade-related investment measures also fall in these notions, and exchange controls or exchange restrictions. Pre-shipment inspections, what is that? That's the practice often used by so-called developing states that they employ, so they hire private companies to check the price, quantity, quality, and also the classification of goods before they're being shipped, so before they are being brought on their way to the importing country. Why do they do that? They want to say, okay, as early as possible, we want to prevent commercial fraud, and also want to prevent producers from evading customs duties. If they themselves have inadequacies, it's a very technical term, but you know what I mean, in their own national customs administration. So if you want, for example, to prevent corruption taking place at the border, say, okay, we'll do that even at an earlier stage, and also by private companies should do that. There is a WTO agreement on pre-shipment inspection that also includes a number of key principles that are applicable here: non-discrimination, transparency, confidentiality, and there shall also be no unreasonable delays. So, as you can see here, once again, and this is very important for economic relations, you don't want any involved party, so the private party, for example, to breach any secrets, to tell some of the economic secrets to other parties, for example. But at the same time, also no unreasonable delays, because then that could again be a disguised restriction on foreign trade. And also transparency, as we've discussed already extensively, key principle in international trade law in general when it comes to quantitative restrictions in particular. What is also regulated are so-called marks of origin. The rules here, or the key rule here, is to be found in GATT Article 9, paragraph 2 of the GATT, where there is an obligation that in adopting and enforcing laws and regulations relating to marks of origins, the difficulties and inconvenience which such measures may cause to the commerce and industry of exporting countries should be reduced to a minimum, and also due regard being had to the necessity of protecting consumers against fraudulent or misleading indications. On the one hand, consumers shall know the origin of a product. On the other hand, however, such measures should not cause difficulties to trade. But what you can see here again, I mentioned obligations earlier. At the same time, however, the wording they recognize that indicates that that by itself is not a strong obligation. It's more, you would say, okay, it's more of a declaration. Another other measure or impediment to trade are so-called transit shipments, and GATT Article 5 of the GATT includes a general notion that there is freedom of transit, so through the territory of each GATT member, and there shall be no distinction on the basis of the flag of the vessels, the place of origin of a product, the place of departure of a product, where it has entered the market, where it is exiting the market, the final destination of a product, or, and this is a catch-all phrase, any circumstances relating to the ownership of goods, of vessels, or of other means of transport. So in other words, you may use the routes most convenient for international transit for traffic in transit to or from the territory of other contracting parties without discrimination. Once again, here there shall be no unnecessary delays or restrictions. Also, there are no customs duties or any other duties that have to be paid if a product only passes through your territory, if it is not meant to be exported to the market of the territory or of the state through which it passes. And also, however, a state may impose charges for transportation. However, they have to be commensurate with administrative expenses. So, in other words, this is not to be meant as a hidden tax or a hidden source of income, but simply, obviously enough, all these charges, they cost some money. You have to apply authorities, you have to establish structures here, but at the same time, these costs shall be covered. But again, this is not meant to be a hidden tax. Then the next main and key provision here is what about state trading enterprises? These are, and it's a very broad definition, and you find that in GATT Article 17. These are governmental, so if the state itself is working or acting as a market actor, as a producer, as an exporter, importer, or non-governmental enterprises, including marketing boards, which deal with goods for export and or import. So, very broad definition, any enterprise that benefits, whether formally or de facto, because of a close relationship between the government and the company, for example, from so-called exclusive or special privileges. So what you can see here is that a key example would be state-owned enterprises, but also companies that have an export monopoly or marketing board could also fall under this notion. And this is something that is very important. Why? Because if you look at current trade affairs, sometimes our system is called or described as capitalism, but if you look a bit more into detail, if you go a bit more into detail, you soon realize that this is not only private actors and privately owned actors that are relevant here, but also quite often they're influenced by a state, they have close connection to a government, or they may also be owned by a state or have special privileges being granted to them, that they have a governmentally guaranteed monopoly, for example. And there are also some rules in connection with such companies. Why? Because they may themselves also create or constitute a serious obstacle to trade. And that's why state monopolies, for example, could discriminate between foreign country markets or between different country markets. So therefore, most favored nation is also applicable or also relevant not only for the state as such, but also through actors that are close to a state or owned by a state. They may also adopt artificial prices that are effectively substituting, constituting substitutes or tariffs. They may also themselves adopt quotas for imports or exports. So if they have a monopoly, it's not the state itself directly doing that, but if it is enjoying the special privilege of an import monopoly, and if they impose a quota, at the end of the day, effectively, that's a quota. Or they may also violate the most favored nation obligation and therefore, for example, subvert normal trade concessions made by a state. And that's why the WTO law, on the one hand, accepts that these governments that have a close relationship in special protection or special rights and privileges guaranteed by states, that they exist, they may exist, they may not. That's, you could say, state capitalism is acceptable for the WTO, it's a reality, but at the same time, however, such countries should act as if they were subject to the same market influences as private actors, and also they have to adhere to the same practices, regardless of their special status. Then, what is also necessary here is Article 17 GATT and the duty of transparency. So, if there are purchases or sales that involve imports or export, they must act, they have to, and I quote, act in a manner consistent with the general principles of non-discriminatory treatment prescribed in the GATT for governmental measures affecting imports or exports by private actors. Then, when deciding or making such purchases or sales, they have to act solely in accordance with commercial considerations, including price, quality, availability, marketability, transportation, and other conditions of purchase or sale. And last but not least, they have to afford all other enterprises adequate opportunity to compete for such purchases or sale. So all of that falls on the notion they have to act as if there were a special market, so as to prevent an indirect circumvention of trade obligations by states. And last but not least, which shall be mentioned, or almost last but not least, which shall be mentioned here, are trade-related investment measures, commonly abbreviated as TRIMs. They can also constitute barriers to trade if they constitute direct or indirect quantitative restrictions on imports or exports. So they shall also not violate GATT Article 11, and this is to be found. There's a specific agreement on trade-related investment measures, the TRIMs agreement, and this also makes this notion or the emphasis on that rule in Article 2.12, paragraph 1. And now, last but not least, what about exchange controls or exchange restrictions? So also, we've talked a lot about that when it came to currency manipulations, because why such obligations or such rules can make it difficult or even outright impossible for an importer to pay for imports or for an exporter to be paid for exports. So then, at the end of the day, they may effectively also constitute significant impediments to trade. And that's why in GATT Article 15, paragraph 9, on the one hand, the GATT members are allowed to apply exchange controls or exchange restrictions, but they have to respect the rules of the IMF agreement, and also any GATT member, any WTO member has a special exchange arrangement with the WTO that also needs to be upheld whenever applying exchange controls or exchange restrictions. But restrictions of controls on imports or exports, if they are meant to make effective such exchange controls or exchange restrictions, they are lawful. And last but not least, however, what you can see here is that on the one hand, and this is the general statement I want to make, the WTO recognizes certain problems, but at the same time says, okay, yes, but you can use such measures, but at the other hand, however, not for political reasons, or not to gain an unfair advantage as a state, or not use it for strategic considerations, because there are rules in place, i.e. the IMF agreement that also, by virtue of GATT Article 15, paragraph 9, has a special connection to the WTO, and also there is a special exchange arrangement between WTO members and the WTO. These rules are respected. You can apply controls or exchange restrictions, but however, not deviate from that, because that would violate a violation of WTO law. So, having said that, speaking of politics, there are two specific types of products where the special interests of producers were also relevant here. Think of textiles. There was, and you see here from the historic year 1974, there was fear among richer countries that the emerging markets or developing countries, the newly independent states that were freed from colonial oppression from 1960 onwards, that now their markets would now enter and overtake, their products would now enter and overtake the markets of developing countries. And that's why a special agreement was concluded, the multi-fiber agreement, abbreviated as MFA, that allowed for deviations from GATT Article 11. So developed countries could allow their textile sectors to adjust to competition from less developed countries, and however only on a temporary basis. So they said, okay, yeah, you have to accept the fact that now you will face more competition from low income countries that produce these products, and therefore these products will be cheaper even if there are high tariffs. But however, we can impose quotas. We can keep imposing quotas to help our textile sectors or textile industries to adjust. But it was meant to be temporary to help them adjust, but at the end of the day they should also face market competition, but it lasted for 30 years. So what you can see here is this was at the end of the day, as understandable as it was back when all of these sectors had to adjust to new competition. However, at the end of the day, this was outright protectionism. So, and this is where the accusation comes from many developing countries that say, okay, you want free markets principles and free trade for your products, but once where we have a competitive advantage and we want to export our products to your markets, there you imply protectionism. And this, as you can see, this accusation is not unfounded. You find it, for example, in this special agreement that allowed richer countries to apply protectionism, to apply quantitative restrictions in connection with textile products. However, then in 1995, the first steps were taken toward abolishing this special status of textiles, and the WTO agreement on textiles and clothing had the purpose of integrating these products into the regular GATT system. So all quantitative restrictions had to be eliminated by the year 2004, and also this had to be taken on a gradual basis, so step by step. And at the end of the day, the United States and the European Union removed most of their quantitative restrictions, however, only as late as 2005, and on 1st January 2005, the agreement to abolish the multi-fiber agreement and the special privileges, you could say, given to producers in the textile sectors in developed countries were then coming to the end. But as you could see in our session on tariffs, there are still high tariffs on foreign textile products, but no quantitative restrictions. And the other product where developing countries have a comparative advantage is the agreement on agriculture. Is agriculture, and therefore there's also a special agreement on that. That includes obligations to reduce the support and protectionism in the areas of domestic support, export subsidies, and market access for such products. So first, quantitative import restrictions and all voluntary export restraints shall also be converted into tariffs, because tariffs, this is the type of protectionism that is lawful, even if we don't like it. And also, no additional quantitative restrictions should be applied or adopted by, in particular, developing countries. However, there might be non-trade concerns that could be relevant here. So food security during the coronavirus crisis, for example, a number of governments said that in such an interdependent global market, once trade flows are restricted, or if there are obstacles due to a pandemic, and then all of a sudden European countries realize the extent to which they were dependent also when it comes to food security on a functioning world market, everyone became afraid. So as you can see here, food security, for example, is one of the main concerns in this connection. Also the need to protect the environment. One of the key arguments, for example, by farmers in developed countries, that they also protect the landscape, for example, and also the way they produce and manufacture products harmful to the environment, yes or no, also relevant in this connection. And last but not least, however, as I mentioned already, because there is a comparative advantage that the developing countries enjoy, that special and differential treatment for their product shall be granted, because this is the one area where they can compete and where they should be able to compete. Good. Having said that, all of these first minutes, where are we right now? 54 minutes have concerned products. Now we'll go a bit further into detail when it comes to trade and services and market access restrictions on trade in services. Where do we start here? There are in general 4 modes of supply of services, and that is relevant when it comes to, and you will see that when it comes to all of the possibilities of states to apply certain market access restrictions, A to D. You will see that in a few minutes on a list when you see these schedules or these concession states have made when they have opened their markets to foreign service suppliers, it refers to one or several of these four categories. The first one, mode 1 of cross-border trade in services, is called cross-border trade, i.e. trade from the territory of one state into the territory of any other state. Then the second one concerns consumption. So if a service that is in the territory of one state is then consumed by a service consumer of another state. The third one then concerns commercial presence, i.e. is a foreign service supplier present with a commercial activity in the territory of another state. And last but not least, the supply of services by a service supplier of one state through the presence of natural presence of a member in the territory of any other member. So the presence of actual natural persons and not only the service provider. These are the four different types of service supply. In general, however, these market access barriers are not applied at the border, but by domestic regulations that govern the production and consumption of services. Secondly, market access barriers concerning all those four modes of supply are possible, and there are also other barriers to trade in services. Keep in mind, remember, there is a distinction when it comes to the extent to which WTO law regulates or prohibits measures affecting international trade in products and trade in services. Because as you could see here in litera D in Article 1, paragraph 2 of the GATT, what you can see here is first and foremost, the presence of natural persons is a very delicate subject. So, first things first, there is no general prohibition of market access barriers. What you do need here are market access commitments, and they are voluntary. So a state itself, a WTO member itself, can decide the extent to which it wants to open its service market for foreign service suppliers. And as you can imagine, WTO members are very reluctant to open their markets to foreign service competition. So they have only committed themselves to say, okay, we will freeze the status quo when it comes to regulations, to prescriptions or restrictions of market access, but not more than that. And again, as in the case of tariffs, here we have a call enshrined in GATT Article 19 to engage in negotiations to progressively liberalize trade in services. That is also done on a request and offer approach basis. But as you can imagine, trade negotiations also here are very, very difficult. Good. And why is that? First, also because the presence of foreign service suppliers has an immediate impact on domestic foreign suppliers, and at the same time, however, also many sectors are particularly important areas of public services. And that's why also already the GATT's preamble makes it clear that there is a recognition of the right of members to regulate and to introduce new regulations on the supply of services within their territories in order to meet national policy objectives. And however, there is a reference to developing countries, given asymmetries existing with respect to the degree of development of services regulations in different countries, that there is a particular need of developing countries to exercise this right to regulate. So what you can see here, this is not only the richer countries trying to regulate foreign service suppliers or service supply in general, but also an interest, a particular interest for poorer countries, developing countries in the parlance of the WTO. So, however, in general, WTO members are free to designate which sectors they want to open and where, however, they want to say, okay, only to a limited extent or not at all. So there is no, even if access is being granted, it is not unrestricted. There might be limitations attached to all of these commitments to order to open the market. Why? Because you want to reserve the right to operate measures that are, if they were not specifically enshrined in these concessions, that would be inconsistent with full market access and or national treatment. And the relevant provision here is GATT Article 16A to F, GATT's Article 16A to F. You have here 4 types of quantitative restrictions, plus 2 of them limit the types of legal entity and also or limit foreign equity participation. So what you can see here, you may impose restrictions or limitations on the number of foreign service suppliers in general. Then you can also restrict or limit the total value of service transactions or assets. B. Then C. There are restrictions or limitations possible on the total number of service operations or on the total quantity of service output. Then you have a restriction as possible to limit the total number of natural persons present in a certain market. And then you also have measures that may restrict or require specific types of legal entity or a joint venture. It's okay, you can access our market, but you have to cooperate or start a joint venture with us or with a company in our state. And also you can limit the participation of foreign capital inside of a given market. And the main case, one I want to mention in this connection, is the US gambling case. Why? Because this case is also, it will come back to us when we speak about public morals, but also relatedly, this is a very important case to show you what is at work when you want to impose restrictions on foreign services. There was a US ban on cross-border gambling and betting services. And the big question here was, did the US violate the commitments it had made under WTO law? And the question you have to ask when you want to find out whether a state has violated WTO law in connection with services, you have to look at, okay, to what extent has this state, i.e. the US, committed itself to make full market access or to grant full market access to gambling and betting services suppliers. And here the big question, the more detailed one, was whether gambling fell under the notion of recreational services except for sporting, because this is the way the US has formulated its market access commitments. So what you see here, this is what such a market access commitment looks like. This is the one by the US. And that's why, as I mentioned earlier, you have to find out, okay, what is recreational? What does that mean at the end of the day? Why? Because these are the four modes of supply. And here you see, okay, are there any limitations on market access? None. And fourth, there's also is unbound. And then also other recreational services. Then there's a number of concessions that are available for commercial operations, and federal, state, and local facilities is limited when it comes to other recreational services. And also the fourth mode of supply was unbound, except as indicated in the horizontal section. So, long story short, the big question is, what does recreational mean? Or in other words, is gambling fun? Or is it closer to an addiction and therefore should not be considered as recreational? And here, as you see in the panel report from November 2004, it defined and interpreted the words recreational, entertainment, and sporting. And here, the panel failed to understand the United States' claim that the operation of facilities such as marinas, beaches, and parks fall squarely within the plain meaning of recreation and are distinguishable from entertainment. Plus, they also said that it is not clear why theaters, dance halls, music halls, etc. fall squarely within the plain meaning of entertainment and are distinguishable from recreation. In other words, the US tried here to make differences or to delineate a difference between recreational, between entertainment and sporting. However, when it comes to entertainment and recreational, the panel held that it seems that the words entertainment and recreation are largely synonymous and could be used interchangeably. So this is just another way of putting the same thing, or as formulating the same thing. And then, as it further then outlined that gambling and betting have, a priori, so at first sight, the characteristics of being entertaining or amusing, or of being used as a form of recreation. And however, there was a commission established in the US, National Gambling Impact Study Commission, that stated that today the vast majority of Americans gamble recreationally. And then, however, pathological gambling differs from the recreational social gambling of most adults who view it as a form of entertainment and wager only small amounts. So, what you can see here, think for example of The Last Dance. This is a documentary on Netflix depicting or showing the life of Michael Jordan during the 1990s, and he was repeatedly accused of being a pathological gambler. But at the same time, however, and this is a very important quote, where Mr. David Stern, the commissioner of the NBA back then, said, yes, the sums might seem like a lot for a normal consumer, the sums that Michael Jordan was gambling on when playing golf, for example, but at the same time you have to remember how rich he was already during the 1990s. So to draw the connection to current Netflix series, the big question, okay, the vast majority of people out there, even if they gamble to enjoy a soccer game, otherwise boring soccer game more, or if they fill out these small sheets and bet on several games at the same time, it makes it more exciting for them, but that's not by itself mean that it's pathological, and small amounts at the end of the day is also a question of proportion. So for Michael Jordan, a small amount might be much higher than for a regular gambler or person who likes to gamble on sports games, for example. And then the big question at the end of the day was the US here was not allowed to restrict internet gambling services originating in their territory. So, however, the other question was, even if the US was not allowed to do that because of the way it has opened its market and the way it has not used any or made use to this extent, it was discussed in the case of restrictions on foreign services in the gambling sector. But the other question then, however, that was left was whether it could refer to public morals nevertheless. Because, as we said at the very beginning, public morals, and as you also saw it on the preceding slide, might be particularly relevant to prevent your population from developing dangerous or pathological gambling habits, but that is a different question. The question here, and we'll come back to that when we speak about exceptions to trade. However, the big question that was discussed here was, is that possible or not? It was not possible because the US has not imposed such or reserved the right to restrict foreign service suppliers to operate on their market. So 3 questions in general. What we learned from this case is that 3 questions have to be asked when determining whether a state has violated its obligation under the GATTs when it comes to market access to trade and services. First, how is the service that is discussed supplied in a given market? Then second, who is supplying the service? And thirdly, how does the measure that is discussed affect the supply of services? And what is also necessary to be highlighted here are some general rules in connection with trade in services. The transparency obligation that concerns all regulations of trade and services in Article 3 for all services sector is also relevant here. So this is the equivalent to GATT Article 10, GATT Article 3 of the GATT, transparency, rule of law, and also objective and impartial procedures. Therefore, GATT Article 6, paragraph 2, GATT's Article 6, paragraph 2a, also the one establishing objective and impartial procedures when it comes to regulating or when it comes to imposing measures in connection with services. And also other GATT's rules, however, that are on other barriers to trade and services, they only apply if and to the extent the WTO member in question has made market access or national treatment commitments. So it depends at the end of the day on the member itself to define or determine whether and to what extent it wants to open its market. So again, the big difference to trade in products. Trade in products, very strict rules with only minor exceptions. Trade in services, much more leeway for states to apply restrictions. Good. That concludes our session on trade in services and goods, and more precisely quantitative restrictions or market access barriers to trade. I hope it was interesting for all of you. In the next session we will talk about unfair trade practices, so anti-dumping, subsidies, and also in addition to unfair trade practices we'll also talk about emergency measures that may be taken on a temporary basis under the GATT Article 19 to be more exact. Having said that, I'm looking forward to our next session and wish you a great day. Goodbye, everyone.